Namaskar. I am Adv.Juilee. I am practicing in the Bombay High Court since past 8 years in the property succession matters, especially dealing with the NRI clients and the overseas citizen of India clients. I have dealt with 100 plus matters till the date, and recently I came across one video on social media which was spreading incorrect information about the succession of the properties by NRI clients. So I thought it is my duty to make a video giving the correct factual and the legal information. One important disclaimer: I will speak only about the process and facts which are applicable in the Bombay High Court because that's where I personally and exclusively practice. So let's get started. First of all, the registration of the will is not mandatory in India. You can register if you want, but even if you not registered your will is still a valid will. Secondly, even if will is registered or not, getting the will probated is absolutely must in Mumbai. And if there is no will, one has to file for either letters of administration or succession certificate based upon the nature of properties involved, and your advocate can guide you better in that regard. Now let's come to the processes for either probate or letters of administration or succession certificate, which are very streamlined and simplified. In the process, the client do not have to make multiple visits to India. Let's get that clear in the beginning. I have dealt with the matters of my clients where I have not personally met my clients even once. The client is sitting abroad. I am handling everything in Bombay High Court. I email the drafts to client. The client take prints there. The client get documents notarized there and send them back to me. So we do not have to personally meet. No multiple visits in India are required. And even the documents which are to be filed in the Bombay High Court, they need only notarization from the local notary, and they don't need any apostille or attested POA in Bombay High Court. Then another important point is regarding the court fees. The court fees which are to be paid to the court in all these matters is maximum 75,000, and it is not some 2 to 3% of your asset value. Even the stamp duty which is to be paid to the government after getting the probate or LOA to transfer the properties in your name is also minimal, and it is not percentage of the asset value. Even the advocate fees are fixed. I do not charge a fee which is based on the valuation. That's not ethical. That's not allowed. So this is important point. The another important point is regarding the paper publication. Paper publication is not mandatory in all cases. In some cases, it is required where the legal heir's address is not known, and that to 14 days notice is required, not 45 days paper publication. So let's get that clear also. The another point is regarding the consent affidavit of the legal heirs. Yes, consent affidavit of the legal heirs are required, but who all are the legal heirs? They are generally the immediate family members, the close family members like spouse, children, or sometimes mother. So your lawyer can make the family tree and better guide you whose consent affidavits are required. It's not true that you require consent affidavit from some distant or some relative with whom you have not spoken for years, or you must have built the bridges. It's not the case. They are generally the close relatives. So the lawyer can guide you better. The entire process is very transparent. The filing is done online. The orders are uploaded online. The hearings happen physically, where we lawyer attend the hearings. The client do not need to remain personally present. But the process is very transparent, streamlined, and not expensive at all. So I would request all of you to get correct guidance from a lawyer in India and accordingly take informed decision. I hope this video helps you all to get correct information. Thank you.